I declare bankruptcy!
That's basically what Utah's Republican lawmakers are doing with their redistricting appeal right now. As you know, back in August, a judge struck down the state's congressional maps and ruled that the legislature's repeal of Prop 4, the voter-approved anti-gerrymandering law, was unconstitutional. At that point, the legislature had 30 days to appeal. In fact, they literally changed the law earlier this year to make it so they could fast-track an appeal when a judge blocks a state law on constitutional grounds. That change was mostly focused on the court fight over Utah's near-total abortion ban, but they apparently didn't realize it would also apply in this case, so they didn't use it. Now, 108 days later, they're in court demanding that the judge give them a do-over so they can appeal before the 2026 midterms. The plaintiffs filed a response on Wednesday that basically said, "You had your shot, you missed, that's on you." Even the Utah Supreme Court was confused back in September, writing, and I'm aggressively paraphrasing here, but why didn't you just use the law that you created earlier this year? Here's the kicker. Lawmakers are accusing the plaintiffs of stalling so that they can't appeal when they're actually the ones who sat on their hands for 3.5 months. In their court filing, the plaintiffs called this tactic audacious in the extreme. But it's pretty on brand for Utah's legislature. The judge is expected to decide whether to give the legislature a do-over sometime in the next few weeks. If you want more stories like this, drop me a follow, or you can read my coverage at utahpolitics.news.